I am Dr. Nuzhat Parveen Khan, Associate Professor, Faculty of Law, Jamia Millia Islamia, New Delhi. Today the topic of our discussion is Jurimetrics, the science of law. The learning objective of this particular subject, Jurimetrics, is the study of science of law. It is made up of two words, juris, which means law, e-matrix, which means ecometrics. Jurimetrics is a step towards seeking new alternatives in the field of legal inquiry and is not to be treated as a science. Jurimetrics involves a strictly empirical approach to the law and examines a wide range of scientific and legal topics that are interrelated. The term Jurimetrics was coined by Lee Levenger in the year 1949, who introduced this word into legal vocabulary later on in the late 50s, and this word Jurimetrics signifies scientific investigation of legal problem. Further, as the use of computers in law practice began to revolutionize the areas of legal research in the evidence analysis, data management, the Jurimetrics gained further momentum in legal researches. In the recent years, an attempt to predict judicial behavior has also taken a mechanical term, for which the term Jurimetrics become more appropriate. The Jurimetrics takes the form of different kind of investigations into legal phenomena by using symbolic logic, behavioral models and mechanical aids. The theme of Jurimetrics in the olden days was not to eliminate the reasons or philosophy from jurisprudence or to find out substitute for necessary values which are an intrinsic part of lawmaking. Further, the Jurimetrics signifies the scientific investigation, especially by using electronic methodologies and by using symbolic logics. We as a law student know that law can develop only by continuously drawing new values and solutions from the life of the community, and this is achieved partly by the development of new laws and partly by the standards and principles which are implied in particular branches of law. And we also know that it is the legislature which is interested with the work of making of the law, and it is further the lawyers and the judges who are scientifically and intrinsically involved in the study of law. So how can we say, or how far the work of a judge, task of a judge in developing the law can be described as scientific? What is the theory? The theory which they follow is theory of logical plentitude. What is this logical plentitude theory which the judges apply while they are developing a judgment? The logical plentitude theory means that the law is not a mere collection of detailed rules, but an organic body of principles with inherent scope of growth and flexibility to adapt to new circumstances, a rational system for the exercise of authority of human being. Further, the doctrine of logical plentitude is to be used in a way to make it a narrowing force, because if a case is decided purely by logical deductions from the actual rules, then we will crush its growth. The growth of the law will be crushed if the logical plentitude theory is applied in strict sense. Further, leading works on jurisprudence, one of the work, Jurimetrics Symposium, contained an introduction to the new discipline of science of law and also a number of the types of works and experiments undertaken. Despite the diverse range of potential mathematical applications to the law, it has been concluded by various studies that the most perfect machine even will never be able to replace the creative efforts of responsibility of man in the decision on a public matter, that is the legal regulation of social relations. The scientific development in the codification of law has also led to the danger of machine-made justice. By allowing a proportion of legal inquiries to be conducted by machines rather than by individual judges may cause judges and lawyers to avoid the responsibility for their hard legal decisions, but to resort to ready-made answers based on computers, which definitely is not a good sign. However, the vast range and huge accumulation of material relevant to the legal process seem to demand some kind of mechanical and mathematical approach, if only towards information storages and retrieval, which means just to sort out the material we can use mechanical tools, but with regard to reasoning the decision, it is necessary that there should be some legal reasoning, and legal reasoning is a process through which data is interpreted as high level concepts. Then further, legal reasoning takes intensive factual interpretations and the drawing of conclusions through heuristic computations. Further, it is thought that artificial intelligence tools, some form of computational models which are appearing nowadays as legal expert system, shortly we can call them LEX. These LEX can be devised for the analysis of legal problems within defined domain, where possible to provide basic legal advice derived from the reasoning processes. Legal expert system is a relatively young industry, and it is a very authoritative definition of this product. It is worth noting that it is with every other kind of expert system which differs from legal information retrieval system is the answer given by the LEX. But the answer given by the LEX depends on who is asking the questions, and they are most of the time very made up answers. Following are the desirable elements of the LEX. They includes high performance problem solvers. They are built with the assistance of human experts. LEX operates in specific problem areas. LEX also help in argumenting rather than supplementing humans. They are not intended for use by laymen. That means those who are experts in the legal skills can use these legal expert systems, and the LEX are transparent also because they explain the lines of reasoning. They are flexible also. Generally LEX consists of or composed of three components. It has one, number one, it is a legal knowledge base. Number two, there should be an inference engine being its reasoning mechanism. Thirdly, it should be having a user interface. The potential contributor of LEX to the general public takes the form of following benefits. The benefits are there, though it is machine made logic, but it has some benefits, and the benefits includes it elevates the workload of lawyers. That is why it enhances the quality of their professional work. It offers public ready access to simple and legal advice at all the times. It also offers the prospect of a much lower rate of legal service knowledge. In law, data is being represented in natural language, which represent the facts and legal case that are human events which may lead to disputes. One of the objective of legal argument is to interpret, analyze the fact of the case and to try to fit the case into the defined rules of law. Now, the complexity of modern statutory provision with collateral amendments, statutory instruments seems to require more than traditional methods to enshrine and expound their meaning, and under those circumstances the jurimetrics with the help of these machinic tools becomes a helpful instrument. The symbolic logic could perhaps provide useful tool to this end. Computers will help in eliminating arithmetical errors and data transportation oversights, through which this may further leads to oversight mistakes can be avoided, which may further bring the information which can be relied by the judges and even by the lawyers while they are dealing with the cases. Computers further ensures uniformity and application of the law becomes simpler. Judges and lawyers with the help of machinic tools can also easily avoid the responsibility of hard legal decisions by resorting to ready-made answer based on the questions. In drawing distinction between a scientific method and philosophic method, the ultimate test of any approach should be in its ability to advance knowledge which can be utilized in solving manifold human problems, as these methods are only means to an end. In this respect, no matter how jurimetrics is placed, whether within or outside the boundaries of jurisprudence, the primary concern is its ability to help in understanding and investigation of legal problems.